SJC-11386, Commonwealth v. Patrick, Grier.
Okay, Attorney Scapicchio.
Thank you so much. May it please the court. My name is Rosemary Scapicchio and I represent Mr. Grier. Today, I'd like to talk about three different issues in Mr. Grier's trial. The first of which are the problems in jury empanelment. The next of which is the problems with the ID. And the third of which is the 33E review, which normally I don't ask the court for time for, but I think in this case it's necessary. So with respect first to the jury empanelment issues, I would ask this court to look very carefully at Mr. Grier's Soares-Babson challenge. What happened on the third day of empanelment is that there were 3 African-American female jurors cleared. All 3 of them were challenged by the Commonwealth. The Commonwealth says in its opposition that we don't know if there were other people in the veneer that were of color. And my suggestion is under Commonwealth versus Ortega, if there was other people, you would expect either that the prosecutor would have pointed that out or the judge would have pointed that out. So we have an entire day of jury empanelment where the only 3 African-American women who are cleared are challenged by the Commonwealth. That, in my opinion, meets Mr. Grier's prima facie case in the low burden of proving that there is a pattern of exclusion. What should have happened under those circumstances is that the trial judge should have asked the prosecutor for a race-neutral reason for the exclusions. Instead, the judge, who wasn't the prosecutor in this case, answered for the Commonwealth and said essentially, I don't see a pattern as far as race is concerned. I see a pattern as far as age is concerned. And I've seen this pattern for every single criminal case that I've ever sat on, and I've seen it with every single prosecutor. They excuse people for age. And the problem with that is that the word young jurors isn't defined anywhere. And so in every single case, young jurors become something different. In this case, young jurors was anyone under 31. In other cases, young jurors are 18 to 21. But if you leave that young juror out there with no explanation whatsoever, it gives the Commonwealth the opportunity to use this type of challenge, this challenge to age, which they say is not a protected class, and use it as a backdoor way to get around a Babson-Soares challenge. So the problem
just okay. So we have a very experienced trial judge, Judge Fabricant. Right?
Absolutely.
And we have, what's the constitution of the jury at this point? It's a very diverse jury, according.
Well, she says it's a very diverse jury.
And was she right?
I don't know because I wasn't there, but what I know the record suggests is that after the judge let the Commonwealth run jurors' records, there was one African-American male who was, according to the defense attorney, the only African-American male on the panel, and his record was run and the Commonwealth chose to challenge him. So if they had a very diverse jury, I don't know what it was made up of because there's nothing in the record to suggest that. But if this African-American juror who was challenged after his record was run wasn't the only African-American juror who was sitting, you would have expected the prosecutor or somebody else to say something.
A lot of ifs there. I'm just trying to get, the facts that we can establish from this, which is, again, Mr. Lynn's going to get up there and say there is a very diverse jury at this point. Also, there is a consistent pattern of striking young people. Now, this one person was 32, I take it, or
31.
31. But youth is not a protected category, right?
Not yet. I'm still trying.
You're still trying, but you keep losing, on that
I'm
one.
not going to give up.
Yep, I get it. No, that's one of the reasons you're so successful. But again, I don't see the basis here.
Well, the basis is,
again, the basis for the particular challenge you're talking about. I mean, that's quite an odd back and forth with that juror, right?
well, there were 3 jurors that day.
Well, I'm not talking about the 3. You said the African-American male who was struck.
Who, when they ran his criminal
That's
record.
quite an odd back and forth, isn't it?
Well, I think the juror was confused.
Well,
And I think it's confusing that they're questioned about only one portion of their jury questionnaire. So to me, I don't understand why we believe jurors when they say they've never worked for law enforcement. We believe jurors when they say they've never been a witness or a victim to a crime, but we disbelieve them when we're talking about their criminal record. And that's another issue that I have in the brief that, I still think that Suffolk County and no county should not be able to run jurors' records. What we know about the practice of
you want us to reverse Cousins.
Yes, for a different reason though, not for the reason in Cousins. So I think the reason here that you need to take a look at it is now we have data that suggests that Black and brown people are stopped proportionally more than any other subset of people in the entire Commonwealth of Massachusetts. If we know that, and we know that they're more subject to arrest, then how are we using their criminal records as a way to excuse them from jury duty? It's a racist practice. That's all there is to it. It's racist. And we can't tolerate that in our criminal justice system. Why do we only disbelieve people when we talk about criminal records? Because we're talking about Black and brown people and we don't think they tell the truth. That's the message that we're sending. And that should not be the message any court is sending to jurors who show up for jury duty. And that's the absolute message we're sending with running criminal records.
So
Why else are we running them? They don't help me as a defense attorney. They only help the Commonwealth. And so if we look at the number of challenges that the Commonwealth uses after running these criminal records, we will see a distinct pattern of exercising challenges to Black and brown people. Why are we giving them that opportunity when we know that that's a racist practice?
the appeal in this case, I take your points. The appeal in this case is what happened with this particular juror and having been there and done this impalement with you, as you well know, if you have a juror, hopefully, and they have an dismissal, quaff dismissal, and they come up and they say, well, I didn't know it was a record. They said it was dismissed. Most judges, I think, brush it off and say, they didn't know, and we move on. But here we had an inquiry with a juror that the judge found problematic, given comprehension and given, isn't that a reason to excuse this person?
I don't think so.
But we got to look at it in the judge's eyes and what the judge found, not what you think.
I understand that. But I think when you realize that jurors at sidebar are always nervous about interacting with the court.
So was the judge clearly erroneous?
I think the judge was clearly erroneous. I think that the juror said ultimately that the juror could be fair and impartial. And once the juror says that they could be fair and impartial, why is the judge second guessing that?
Did trial counsel object to this?
No.
Okay.
Substantial risk of miscarriage of justice. I
Right, but
understand.
isn't that a sign that,
No,
the defense, it's not?
it's a sign that the trial attorney missed it. That's what it's a sign of. It's not a sign that it's not an error. Clearly it's an error. Because in this case,
No, I know what our standards are. So, but here, the issue is whether or not we accept the judge's findings of fact and why they're clearly erroneous, where the defense attorney didn't even recognize it as an error.
right.
And you don't bring it as an ineffective assistance claim either.
Well, we were planning on bringing ineffective assistance in a motion for new trial, but this court ordered us to file the brief first. There's an objection that I put on the record that's in the record. I think it's at number 34, where I put on the record that I thought it was unfair to force me to file the brief in this case before the motion for new trial. So yes, there's going to be a motion for new trial.
How old is this case?
2013 is when I took over.
How old is the case?
It was a 2010 conviction.
All right.
The transcripts were ready, I believe, in 2012. And I took over in 2013. And I can tell this court exactly, if the court is wondering what I was doing for those 4 years, I have a problem with the facts in this case. I have a problem with the way that the testimony came in. I do not believe that Mr. Grier is guilty. And I want this court, and this is my 33E argument, so I'll do it right now. I would like this court to look very significantly at the identification issue in this case. Ms. Day's testimony makes no sense. She's the one with the gun. She's the one who says that my client ran from Lyndhurst Street down Washington Street to Aspinwall Street in front of the bank, in front of 1 million people, tossed a gun to her from the middle of the street over to where she was on the corner. Except when she testifies, she says, as soon as she hears the shots, her and Lewis run down Aspinwall Street. That's what she says. And so how can she be running down Aspinwall Street with Mr. Lewis next to her if she's also supposed to be at the corner trying to get the gun from Mr. Grier?
Well, was that the subject of cross-examination or inquiry by the trial attorney in front of the jury?
Not to the extent that it was very effective. I can tell you that. I don't believe that
it did occur. It just wasn't effective.
it did occur in some sense, but not in the timeline that it should have. And so I'm asking this court under 33E to look at that, because Day's testimony is that she was running down Aspinwall with Lewis on her left-hand side, that they were both on the sidewalk. Lewis disappears out of nowhere. And then all of a sudden, my client, who has asthma, catches up to her. He has to run from Lindquist down to Washington, halfway down Aspinwall. And according to where the gun is actually, or the hat is actually found, she says she sees my client take off a hat and throw it next to the parking lot near where the bank is. Except that's halfway down Aspinwall Street. None of it makes any sense. The testimony that she has doesn't fit with the evidence. And then when you look at the identification, which I'm sure this court will, I'd urge you to look at the surveillance video, because this is what it is, okay? You can't see anything from this surveillance video. You can't make out a person. You can't tell who he is. But somehow the Commonwealth blew this up and said that this person that was here was wearing this jacket and committing this crime with a hat on. Except when you look at the person that they blew up, he has no hat on. And so the theory has to be that my client had a hat on, and then he took his hat off to do the shooting, and then he put his hat back on to run down Washington Street and Aspinwall, and then took his hat off when he saw Miss Lewis.
He has gunpowder on his jacket, right?
He has gunpowder 4 months later on the jacket. Yes, he does. Gunpowder typically, as this court knows, the test should be done within 4 hours. So either the Commonwealth of Massachusetts got very, very lucky, or there was some sort of contamination. But there are problems with this case, Judge. And I just ask you to look at it on 33E review, because it doesn't make sense.
Can you take us through Divine's testimony and the use of the arrows and such, and his opinion of identification?
Yeah, so his opinion of identification is that you can tell from this still that they blow up, that there is a C on the side of this person's jacket.
So, and forgive me for not knowing the record, you obviously know it well and I'll know it better, but as far as the use of arrows, like Wadsworth type stuff, what happened here as far as enhancements or arrows or direct testimony that we prohibit as far as the police officer giving that opinion?
The police officer, it was Detective Devane,
Right.
took the stand and said, I think on 3 different occasions, that he and other members of his squad reviewed the video numerous times, several times, reviewed it, I think at one point he said to exhaustion. And then he gave the jury the opinion that this person who was here in the video, who was blown up, he was focused on a C on his jacket, which they claim this photo has a C on the jacket.
Did he say, look at this video, you can see the C? Or
Yes. Oh, yeah, you can see. I was focused. What he said was, I wasn't looking, because someone asked him, did the person have a hat on? And he said, oh, I can't tell whether the person has a hat on. And you guys can look. He clearly doesn't. And he says, I was focused on the C on the side of his jacket. And then they put a big picture of the jacket they say Mr. Grier had, and they're saying there was a C on the side of this jacket. That's how they make the identification of Mr. Grier.
did they do the thing with the arrows?
Yes, the arrows were in where the C was, and then in where the C is on this. Yes, they did that at this trial. And you know, under Commonwealth versus Wadsworth, we know that they can't do that they shouldn't have been able to make that claim that it was the same jacket.
And you know, in some of the other cases we've had, they've given an opinion that didn't happen in this case.
It did not. It did not. But it didn't have to, because you're telling him that this is the jacket. You're telling him it's the C. It's almost like Commonwealth versus Williams, where you're identifying an object, and you're telling them that the object is the same. You don't have to say the words "and it's the defendant" when clearly that's the inference, and that's what the Commonwealth argues in its closing. It's there. The identification is made because the strange thing about this case, and again, we go back to the 33E argument, is that none of the civilian witnesses identified Mr. Grier as the shooter, and they all had the opportunity to do it. Betty Smith, who was right there, she looked at a photo of Grier and said, that's not the guy I saw. And in fact, she said the guy I saw had a B on his hat, not this hat that they say had a pinwheel on it. She said it wasn't the same. And then if you go down to Lorraine Sanders, she says, I saw pants, and they showed her the pants that they say were Grier's pants. And she says, they're consistent, but that's not them. It's not those pants. That's not the same thing. And the third witness, Miss Deborah McKenna, who testified, said that there was actually a different man there, an additional man with a red jacket who also ran down Aspinwall Street. And she doesn't identify Mr. Grier. So the only identification they have is through Detective Devane, who says that all of these arrows mean something significant. And he looked at the video with all of his police officers a number of occasions. He talked about the FBI helping them to bolster his testimony about what happened in this case. And that's how the ID was made.
But he never says that he never says this is the defendant.
He doesn't ever says this is
He
Grier.
never
No, he
says
doesn't
this
use
is who
those
it
words,
is.
Your Honor.
And by the FBI help, he means enhancement of photographs.
Enhancement of photographs, talked about, at the time, Green worked for the FBI, talked all about Green and what he could do and how they needed the FBI's help, and that's what they did in this case. That's essentially how they identified my client as the person who they said was involved. There's one other issue, I know I'm running out of time, that I'd like to get to, and that is the instructions to the jury to disregard their life experiences when they're serving jury duty.
I read those instructions. It seemed like the instructions that just about every judge gives, and I think you're taking them out of context, but go ahead.
I disagree, Judge. So first of all, and most respectfully, I disagree.
Disagreement's fine.
So there are three different, so the Commonwealth says in their brief that in this case, it only happened on one day. That's just not true. So I want to point the court to the 3 days of jury impanelment and the 3 days that she makes the same exact statement. So on day one, and just so the court knows, there are two volumes. One is June 1st and one is June 2nd. They both say volume 1, but they're 2 different days of trial
So
testimony.
this is during the instructions, the preliminary instructions to the jury, where Judge Fabricant says these things, right?
She tells them essentially to if they've had any experiences, to leave them outside and not bring them into their deliberations. Any life experiences, any other experiences, and you know, that's pretty instruction as far as the jury is concerned. I think that's pretty limiting, and I think the court has already said in cases like this that you can't ask the jurors to leave their experiences at the door. In fact, that's why we have a diverse jury, to have all of the different experiences. But let me just get back to the 3 different occasions, because the Commonwealth's brief said there's only one. So on day 1, which I named June 1st, it says volume 1, page 38. On June 2nd, which they also say is day 1, it's page 15. And on day 3, it's page 24. So those are the 3 different places in which all 3 panels got the same instruction. And the instruction essentially was, when talking about whether or not they could be fair and impartial, that they should leave their experiences, if they've had any experiences, they should put it aside, and their life experiences and their beliefs in order to serve. That's erroneous. And I agree that there was no objection by the trial attorney again, but to all 3 panels, the judge asked them to put aside their life experiences and their beliefs in order to serve. What do you have left if you don't have your life experiences and your beliefs? Well, how do you decide the case? And she said, and decide the case based only on the evidence that you hear in this courtroom. And that's pretty powerful instruction for a judge to give a juror before they get impaneled in this case. And if we are to believe that the jurors follow the judge's instructions, there was no other instruction that told them differently. They were told to, in order to serve, they had to put their life experiences and their beliefs aside. And this court has already said that that's improper, that no judge should be instructing any jurors to put their life experience and their beliefs aside so that they can decide cases. In fact, it's the exact opposite.
Didn't she say being fair and impartial doesn't necessarily require that you've never heard anything or read anything or had any experience
She
or
did.
opinions of views that might in some way be relevant?
Yes, she said that statement.
There are probably a lot of people who wouldn't fit this description.
Yes.
Okay, so doesn't
And then
that-
she goes on to say, right, that next line, where she says, put your life experiences and your beliefs aside. That's the problem. I don't have the problem with her saying not everyone fits that. That's no problem. Any judge can say that to a jury. But when you say to all 3 panels, put your life experiences and your beliefs aside in order to serve, that's the exact opposite of what we want jurors to do. We want jurors to bring their life experiences into the courtroom. We want jurors to bring their beliefs into the courtroom. That's how we get a diverse jury. And so if jurors believed that they couldn't put their life experiences or beliefs aside, then they believe they couldn't serve jury duty.
But we also want them to focus on the evidence and put aside any personal biases and things of that nature, right?
We do. And so when you say personal biases, I think that's what makes the difference, Judge. When you talk about personal biases, in other words, the question that's always asked in Suffolk County, would you believe the testimony, believe or disbelieve the testimony of a police officer simply because he's a police officer? There are a lot of jurors who will raise their hand and say, I had experiences with the police and I don't know that I can be fair and impartial. Clearly that juror has to be excused because he had personal experiences that made him biased. That's not what this instruction says. This is a general instruction saying, put aside your life experiences and your beliefs. That's the difference. Not that it's personal to you,
Well,
but your
but-
life experience and beliefs.
They are personal to the juror. inherently.
But you're telling them don't use them in deciding this case. That's what you're telling them, that you're precluded from using them and you're limited to only using
She also gives the standards instructions about reasonable inferences and common sense, right? I don't know. It's quite different from the case that you're relying on, where there's a back and forth with a juror, where she says, look, based on my experience as a juvenile expert, I really think people are unfair to, minority use. That's a different exchange than this one, which is just sort of preliminary, instructing to focus on the evidence. I mean, this isn't really a reversible issue, is it?
May I answer, because I know I'm out of time?
Yes.
Thank you. I believe it is, and the reason I believe it is because we don't know, there was no individual colloquy with these jurors. We don't know which jurors believed the judge when she gave this instruction and followed it.
We do have 3 jurors who raised issues surrounding this instruction, correct?
There were 3 jurors that responded to the life experiences and beliefs. Yes, we do have that, Judge, but we don't know what other jurors, if they just follow the judge's instruction. She said, leave it aside. I'm going to leave it aside. I'm going to decide this case based only on the evidence I hear in the courtroom.
Instruction though, it came to the panels, right?
It did,
And
the
it
3 different panels.
It wasn't repeated in the final charge that way.
It was not repeated in the final charge, no. But we don't know who believed it and who abided by it, because we have
Never
to.
know that, do we?
I'm
With
sorry?
any of these instructions.
well,
We
I think
never
this-
know who's listening.
I think this court assumes that the jury follows the judge's instructions.
Right.
And so if the juries follow the instructions in this case, it's reversible error. And Mr. Grier should get a new trial. And if there are no other questions, I know I'm out of time. I'd ask that this court look very seriously at the 33E issue. And I'd ask the court to reverse Mr. Grier's conviction. Thank you.
Thank you. Attorney Lynn.
Good morning, Your Honors. May it please the court, Paul Lim for the Commonwealth. I too would like to start with the bats and sores issue. When the defendant raised this, excuse me, I'm vaccinated, sorry. When the defendant raised this bats and sores challenge on the 3rd day of trial, the judge did exactly what she was supposed to do under Jones, and she looked at those factors that are set out in Jones. The first thing she asked was there an apparent race-neutral reason on the record for these challenges? And she found, yes, there is.
Was this before Issa or after Issa?
This was before Issa. This was 3 years before Issa. So she looks at the Jones factors. She asks, is there an apparent race-neutral reason on the record? And she concludes, yes, there is. The prosecutor has been challenging young people. She then asks the next question, which is, has the prosecutor been applying this consistently to both Black and white jurors? Concludes, yes, he has. She looks at whether the prosecutor has challenged a disproportionate number of the jurors, and she finds there's no evidence of that. There were dozens. I counted 57 jurors that were cleared by the judge that were up for peremptory challenges. So almost 60 jurors. And we have a record of 3 of those challenged by the prosecutor. So the judge was well within her discretion to say, no, there's no pattern of discrimination here.
But we don't know how many Black women were in the jury pool.
We do not, but that's because there was no record made. That's the problem here. The judge does say, we have a very diverse juror. And I want to point out one thing
But
regarding the conversation.
We've said that's been problematic before. We've said we've got enough isn't an answer, right? You have to look at the peremptory challenges before you.
Oh, absolutely. Yes, that's the Sanchez decision. You can't just say it was a diverse jury,
There's
therefore that's
about-
the end of the argument, but that's not what she did.
There's about three cases that say that.
Yes, but the caveat that this court has said ever since Sanchez is they will say, also the judge noted that there were other minorities on the jury, which is not in itself enough to justify a peremptory challenge or to foreclose the inquiry into peremptory challenge, but it's still a relevant factor.
And I'm sorry, good. This is obviously, and you answered it, this is before ISA, but is it a problem when it's the judge that supplies the race neutral reason as opposed to asking the Commonwealth to do so?
Absolutely not. The Jones factors explicitly set out that the judge should consider this. It's also, there's plenty of cases saying the judge can raise and conduct a Batson source inquiry sua sponte.
Yeah, but we have a challenge. It wasn't like the judge, the defense attorney did make the source challenge, Batson source challenge, right?
Yes, the judge, excuse me, defense counsel did make the Batson source challenge.
And I think the point that Mr. Capiccio is raising is why is it that the judge that comes up with the race neutral reasons as opposed to making the Commonwealth come up with those reasons?
Because under Jones, certainly before ISA, it's not until ISA that this court ever says the judge should think long and hard before she doesn't ask for an explanation from the prosecutor. Here, the judge has been watching the entire panel process over 3 days. And she says, I immediately noticed that the prosecutor was challenging young people. That happens in every case I've ever seen. He's challenging young people. There's just no evidence.
What about the age 31 problem?
Well, there's two things about the age 31. The first is there's no showing on the record that there was anyone younger than 31 on the jury. In fact, defense counsel complained that the prosecutor was stocking the bench with middle-aged people. Or it's not the bench,
That
the
seems
jury.
like quite a stretch to say that someone is 31 is a young juror.
True, Your Honor, but what you end up with then is one challenge out of 57, and the defendant does have the initial burden to show that this was not a proper challenge. The presumption is that this was a proper challenge. So over 3 days, you have 57 jurors, you have 15 peremptory challenges by the prosecutor, 16 by defense counsel.
Where do we go if we think that the judge made an error by saying the 31-year-old juror is a young juror?
No, the judge never said that.
I thought the judge said that the reason why we don't need to inquire, there's no pattern because the 31-year-old is a young juror.
No, she never says that. She says there's a pattern. The pattern is he's been challenging young jurors. She is referring there to the fact that the prosecutor has challenged 3 African-American jurors that day.
And maybe I'm confused. I thought the 31-year-old is one of the ones that are at issue.
That is correct, but
Okay.
the judge never says, oh, 31 is young.
Right.
She is saying, I don't see any evidence of a pattern here. I see a pattern of challenging young people, which is entirely proper. I don't see any pattern.
Normally, those people are college students and all the headaches that are caused by picking college students, right?
Yes, no, there's no question. This is not a
Go
particularly
back to race
young
and
juror.
sex for a minute,
Mhm.
which are the protected classes,
Yeah.
right? Race and sex are protected
Correct.
classes. Those are the ones that are recognized under Batson Soars. Age isn't, correct?
Correct.
And neither is a diverse jury because we don't know what that means. Or minorities. That could mean many things that are not necessarily protected by Batson Soars.
Correct.
So, but when we take race and we take sex, we put them together, we have a pattern of race and sex, which is a unique status. It's 2 statuses, but
Mhm.
they're combined. And why does that not create the pattern that we're concerned about?
If you'll give me half a second here, I can find the exact case that I'm looking for here. It's Henderson. It's the most recent case. In that case, the prosecutor, there was a record that the prosecutor struck 3 of 12 Black people in the venire.
But do we know were they male or female in that case?
We don't know if they're male or female in this, but the point is here you have under the best case scenario for the defense, you have 3 jurors out of 15 that were a member of a protected class. And we can say that yes, you can say that protected class is Black women, although that's not, well, I won't say that. The defense counsel does raise that. I do say that. So you have 3 out of 15 or 3 out of 57, depending how you're looking at it. There's no evidence whatsoever that the prosecutor in this case challenged a disproportionate number of jurors. So you have these two jurors on the third day who are admittedly young. So they fall under this umbrella of the young jurors.
well,
That leaves you with
So does
one
age-
challenge.
Age
two or
take out the
two.
race issue?
But hold on,
What-
but can we finish on the three young people for a second?
Yeah.
Just to clarify, so two of them are young and one's 31.
Correct.
31's getting younger every year for me, but.
Yes, and
okay,
me too, Your Honor.
But that is a little odd, so.
But you're saying that the judge basically said the 31-year-old female is a standalone. The judge is saying there's no pattern.
Exactly.
And
That's
the
exactly
only
what I'm
pattern I
saying.
see is young people.
Right. So you have this one-
So the challenge of the 31-year-old could have been 42 years old. It doesn't matter. That's what you're saying.
Right. It certainly is better for the Commonwealth that she was 31 and not 51. But yes, absolutely. What matters is that there's no showing of a pattern. You can't just cherry pick the morning of the third day. You have to look at the entire impanelment. And the question in an abuse of discretion, even under Batson Soares, is not whether this court would have
But
asked the prosecutor, but whether.
and I don't remember the names of the cases offhand, but we go back to the other cases where we've said judges get in trouble, even pre-ISA, because these cases are old, and pre-Sanchez, of course. Judges get in trouble when they start basically looking at the jury composition and saying, good enough.
I would disagree with that, Your Honor. I think at least before ISA and before Sanchez, there is a ruling by this court. There's settled law by this court that the judge does not have discretion to even ask the prosecutor until the defendant has met the first prong of the Batson Soares challenge. That has changed since the trial. So the judge here is acting entirely properly under the law at the time. She's looking at the Jones factors. She's looking at all of them.
But these are constitutional rights.
Oh, absolutely. The right
so-
to
Right, so I don't know, I mean, it was obviously, and probably unfair of, well, maybe not, but the law, our Batson Soares law has changed dramatically. Correct?
I would not say it has changed, certainly, but it's
Well,
the
Judge Fabricate, in
standard.
fairness, was following pre-ISA law.
Correct. The
And-
judges follow.
But that hasn't been a refuge for some judges who have been reversed.
Yes, I agree with that. But you're looking at the right that has existed since 1979 in this Commonwealth is the right to a jury that represents a cross-section of the community. The defendant has always had a right not to have,
But we've never
Peremptory challenges.
said in ISA and all those other cases that this is prospective.
no, but
Because
this
we're
is
interpreting a constitutional right.
correct. But you have still said that it's a matter of the judge's discretion. If I might find
Are
that.
you saying that here, Judge Fabricant does two things?
Mhm.
One may be more problematic than the other, but the first one, she says, is the only pattern I see is youth.
Correct.
And then she also says, the jury before me is a diverse jury.
Correct.
Um,
I would put out there's nothing
Is the
wrong with that.
combination helpful for her? Meaning, if she just said this is a diverse jury, that's a no-no for the reasons we've said later, which is, you don't get to stop doing that. You don't stop considering whether the jury is diverse once you have a certain number. But she also says the only pattern I see is this.
Yes,
And that seems to be different from the cases where we've reversed.
I agree 100%. What she's doing, as I said, the first words out of my mouth today, is she is going through those Jones factors, which is exactly what she's supposed to do. And I would point out one thing on the record.
But before you do that, can I just ask you, isn't the point though of this not just the defendant's rights, but the jurors' rights to be
Yes.
on the jury?
Yes, the
So-
jurors are
So
entitled.
if you have a subset of jurors that are members of two protected classes that are
Correct.
excluded, and it's their rights that we're concerned about, what difference does the diverse jury make?
It's just one of the factors. It shows that the prosecutor is some evidence. It is not conclusive evidence, which of course that would open the door to prosecutors leaving one Black person on the jury and challenging everyone else. But it is one factor among many that shows that the prosecutor is not, in fact, using peremptory challenges to prevent people of protected classes from serving on the
And
jury.
now is one of the Commonwealth's, is the witness the key witness to, I forget her name.
Mrs. Day, yes, or Miss Day.
Yes. She was important to the Commonwealth. She was testifying under an agreement.
Correct?
Was she a Black woman?
She was, yes.
So is there some suggestion there that excluding Black women from the jury has some effect on the jurors' perception of the witness?
That's a tough question to answer because there's about three different parts to
Right.
the answer. But the first question, the first answer is, if the defendant doesn't show that the prosecutor is challenging jurors based on their race or sex or a combination thereof, that's the end of the inquiry. But yes, of course, that's why we have diverse juries, is so that people will consider the different perspectives that they have. But that also is further evidence that the prosecutor was not using these peremptory challenges for race-based reasons, because he would want people who were sympathetic to our young Black female key witness to be on the juror. There's no reason why he would want to exclude Black women from this jury. So the judge goes through the Jones factors. She finds that most of the Jones factors,
If we go through this record, Mr. Lynn,
yes,
are we going to be, Justice Cypher says, look, we've identified when we have the nexus between a Black person and a woman, so we have a Black woman, that is a protected category. right?
correct.
We're not going to be able, when we go through this record, to evaluate how other Black women were treated.
Not at all. There's no
Nothing in the
record of that. I would just point out for the record that when the court is examining juror 89, who's the Black male who's ultimately stricken, who had the trouble answering the questions, he starts by saying he's one of only 2 Black males on the jury. And then later in that same paragraph, he says he's the only Black juror on the panel. So it's very ambiguous what he means. The judge doesn't address that because the judge says that doesn't matter. We're here to determine the qualifications of this particular juror. And that I'll segue just very quickly to that issue. Even defense counsel at page 53 of volume 3, who is advocating to keep this juror on the jury, says he had some trouble answering the questions. Prosecutor says that, the judge says that, and even defense counsel says that. It's pretty clear on the record, but it probably was even clearer in person. So the judge acted well in her discretion by dismissing.
Can you address the use of the identification
Yes.
articles of Colden and whether or not Devane, right?
So I missed that, sorry.
It's Detective Devane.
I'm not
Divine,
sure.
Devane, anyway.
It's Divine, yeah, I think.
Divine, anyway. But is it the functional equivalent of saying that this is the guy when you say, look at the champion logo and here's the jacket we got the guy wearing, it's a champion jacket, fill in the blanks. Why can't you just put the photographs up? Why do you need the police officer to say, hey, look here? If the photographs are what tells the story.
Right, and that is largely what the prosecutor did.
But I mean, obviously, I know it's trial advocacy, but you could have put the surveillance photograph up and you could have put the photograph in the closing argument. The prosecutors pointed to the champion logo,
Yes.
pointed to the champion logo.
And that's important.
Why does a police officer do that?
Well, the police officer just says, as my sister admitted, I was focused on the C on his jacket. The prosecutor, because I think this was pre-Wordsworth, actually tries to ask the detective, and did that appear to be the same jacket? And the judge, to her credit, says, objection sustained. You can't say that. And that's the distinction. You can certainly put up the picture of the jacket. We could have zeroed in, take another picture that zeroed in on that C. But instead, we introduced a photo that had one red arrow, by the way. This is not Alice's Restaurant. They're not circles and arrows describing each one. There's a single red arrow pointing, and I'm not sure, I don't mean to be harsh here, but I'm not sure what my sister was showing the jury because the exhibits are missing. We're trying very hard to track them down, and if not, to recreate what was there. But as best as we can tell, it's a photograph based on our records. It's a photograph with a single red arrow pointing to the C. That's all it is. And then there's the jacket. I am reasonably certain that although I again, we don't have the exhibits, but I believe that the photo of the jacket itself, the one we know is the defendant's jacket, does not have a corresponding arrow on it. It's
I'm-
just the jacket.
So I'm confused. When we do our 33E here, we're not going to have the exhibits?
Correct. And that's,
And so what is Ms. Scapicchio showing us then?
I wish I knew. We have photographs. We have hundreds of photographs. It's the digital age. What we don't have is a definitive way to determine which photographs were actually admitted in evidence. I think we would need Attorney Apfel, or at least somebody who was involved in the trial. And yes, I think that's something that should be done.
Do we know why?
Why what?
Why why we're handicapped in this manner?
I don't know. I have talked to the clerk's office. I have talked to our keeper of records. It appears that after the trial, the exhibits went directly to the clerk's office. They're not there now, or they're not where they should
This isn't
be.
a co-defendant case, right, where they were used again?
No, there's no co-defendant in the case.
So I'm just trying to, how are we, because we're going to go back to our offices and start writing this case. Are you working on solving this problem or trying to, what are we going to do here? on this?
I think we need, if you are concerned with the
Oh, we have to-
exhibits,
we-
which I think
we
you
always-
Well,
should.
we have a statutory duty to do
Yeah, I
so.
guess-
Not-
okay,
not-
sorry, I
Not
take
only
that
are we concerned, it's our job.
I think we need to get together with the defense and see if we can figure out, because I think the photos that as far as I could see from an angle, appear to be the photos that we think were admitted in evidence. So I don't think it's going to be that hard to determine.
Is
to
there a
agree.
surveillance video?
There is surveillance
Ms.
video.
Capicchio says yes.
Hmm?
She's not, she's
Yeah,
not
I
in her head yet.
believe the video, I'm not sure, I'm not going to say, because I really don't remember, and also that's not part of the record.
Well,
my notes-
you'll be hearing from us.
Yeah, and I welcome that, because it's something we ought to do. You should see the records, because on my sister's 33E argument, when you see that photograph, you will see a C that looks exactly like the C on the defendant's
Attorney
jacket.
Lynn, what about the fact that, well, the defendant conceded that the still images from the surveillance video depicted him and Day, correct?
Correct.
So we do have that in the record.
But that's at a different point than the incident, correct?
Well, it's leading up. It's in the minutes
Right.
immediately prior to the incident.
Right.
I see my time is up. Does the court have any further questions?
I think we're all set. Thank you.
The Commonwealth will otherwise rest on its brief. Thank you.